Item number 2. In the direction the vacation code to file an affidavit.
Which one?
Item number 2. In vacation code it listed for first time against the order of the Honorable Single Judge, they file a writ appeal. In that order, my lord directed to file an order of the CRPX authority dated 25/2020. That order will file by way of affidavit or some give some time. Or there is no need to file because already transfer is given. He has relieved. He has treated more than 3 years.
No. I have not written the relief.
More than 3 years.
I have not been relieved.
Anyway, the court has observed.
That's right.
The court wanted that order to be fixed. Can't you give me a copy of that?
Yes, that copy we have. Yes.
Just now, my lord, I have received the copy of the same. Just now, I received the copy of that order.
Very plain order. That is
It is
the
directed to government repository.
These minutes from yesterday also. What matter?
yes.
The same batch.
Same pattern.
And
Already-
now distinguishes the facts.
We have received the instruction that case already relieved there. Here is a relief, but about joining, we don't have any instruction.
I have not been relieved. In this case, my lord, I have not been relieved.
He is in medical leave, but he was relieved. My instruction will such.
This is the order by which the authorities have rejected your prayer for extension in the same station. So now it means that
Let him sign the affidavit, my lord, I will take instruction on this.
in the transfer matter, how far the court should interfere under Article 226.
Your my lord,
What is the
my
scope and jurisdiction of 226 in a transfer? What was the law?
I will take instruction regarding this.
Regarding this, it's the order of rejection of your representation for extension of time, nothing more than that. It is simply a rejection of your prayer. That's
Then, my lord, a fresh cause of action arisen for the petitioner to challenge this order.
what you were challenging in the writ petition.
Order of the single judge law.
I mean,
So also the
I talk about writ petition.
Right.
What you were challenging in the writ petition, I'm talking
Order of
about
transfer.
order of transfer.
order of transfer, but not the order of rejection of your prayer.
Yes, my lord.
This is the
Yes,
second.
my lord.
So let him, this is the fresh cause of action that has come.
Yeah.
Oh, they are challenging two. I'm just reading a pair for a moment.
He says that he is simply challenging the order of transfer.
I'm just
This is
reading
the
the
rejection of his representation to remain there in Shikanya.
Yes.
This is the separate cause of action.
But they are telling the two annexures. One is annexure 5 and annexure 7.
That was repetition.
That is the repetition which was
Repetition and
rejected.
the order of transfer.
Annexure 5.
John. Complete. Annexure 7 is the rejection of representation.
It is the 20th of May.
No.
10 to 26.
Yes. That was a separate. That was a
Oh,
separate.
that was the second representation.
Yes.
Huh?
My lord.
Then there is no fresh cause of action. It has merged with the second.
No, my second representation is pending. This has been considered by this order.
You can observe, Mr. DSG. Because if it is a device which they have innovatively adopted to delay the entire thing, you will say that in the event you take a decision, you do not adjust those absences as a leave on duty. Don't ever.
What is happening? Who are coming to Bhubaneswar and they are not ready to leave? Rule 7 is very clear. They have to serve the all over
And
India.
suffering from medical illness.
That's why we
On
give
the
you
ground of
citation.
that, Milord, I have filed the representation.
Cited bill was provided.
And Milord, they are standing order. That standing order is their own standing order is providing that.
Then also taken under this medical, board.
Yes, board has given the report in favor of
He's
me.
suffering from various infections. This does not permit him to continue in service.
Service, yes.
He could take a decision immediately.
That's me as well. Be
Or transfer. Better. You are suffering. Medical emergency. You better.
Milord, my prayer is you Lordship have given liberty to challenge this order.
Disciplined organization, sir. I mean, it's not a normal civil services where one can think of. Is it discipline? If there is any kind of such situations, then very strong signal.
My health condition is improving, Lord. My health condition is improving. I pray only 1 year. I am not denying that I
You have
will not
already-
go outside.
That was order of transfer was passed when.
It was in 2025.
And even if
And
Even
today-
effect from
today-
January 3rd,
today- what is
26th.
the date? Today, what is the date?
Today is 23rd, 600.
Yeah, what is the date of the order of transfer?
22/12/2025.
So how many days, months have already passed because of the litigation?
Milord, medical board has, their own medical board has given the report in favor of me, Milord. They are,
Understand, sir, understand. There is no difficulty.
and I am not denying that I should not go outside, Milord. I pray only 1 year, my health condition is improving, and I will go outside, but only 1 year I pray for that.
This cannot.
Milord, this is the second cause of action, liberty may be given to challenge that order. This is the second cause of action, so
This one, we'll say that it becomes absolutely extinct because of the second representation being disposed of by them. And which is challenged in the writ.
my second, this is the
Second,
second.
your prayer.
Milord, the second representation has been considered by this order, Lordship. So this was not on challenge. This was not absolutely that was not on challenge.
What is this annexure 7?
This is a non-speaking order. They are supposed to pass a speaking order. Again, we will pass the speaking order. Out of the self-representation, they are saying that the non-speaking order we have rejected. This one line order of the authority was not satisfied by the court.
Liberty may be given, Milord, that the petition.
Near about 5 years.
Mother is superhuman
9
cancer.
months.
Petition for mother is superhuman cancer. I mean,
That ground we have extended 1 year. Then
now I find that
she is under treatment. There is no dispute there, but we have given
on the hill
sufficient accommodation. We have extended his case.
Can you show me, because I am still in a very confused state of mind, that how far the rate court should interfere that in an order of transfer?
That's right.
I am always grappling with this kind of situation. When, how, where, and what.
And only 2-3 was there. Operation will undergo.
Then you got one or two judgment there.
Yes, yes.
That, restricted the interference.
I really agree with you. But I want only 2-3 months, not 2 months.
Transfer.
Because in the next month, my mother will undergo an operation. Only for
But you take care, you take a leave, you go there, take care of mother, you go take that on that ground, they are so inhuman that they will not permit you a leave.
Already we have considered for last 1.5 years.
That is the leave he wanted. Exactly. He can apply for a leave to.
In that technical part, I'm just clarifying, let this join in Manipur, have an application, accordingly, you will consider
They are,
after
they cannot,
getting
my
the
lord.
application from this. Here, because he's leave, we don't have any scope.
This is the which organization? This is the
Battalion.
battalion, no?
Yes.
It's a disciplined organization.
Yes, I
What can be done?
only for the operation of mother, I want only 2 months, that only 2 months time. only.
Let's see, then my hand something my lord, without considering my, yes, let's see, as provide that he joined in Manipur, he should join in Manipur, submit an application. That application may be considered if he is entitled to get it.
So he'll have to be very fair and straight on this also.
So, but we can't consider because he's a force and everybody is coming and nobody is ready to leave this place.
No,
Here, more than 1,000 forces there. Every season, we are getting 100, 150 cases and transfer. All are coming and nobody is ready to leave this police. I asked this concerned IG, what is the cost of the issue? He told me this only regiment is inside the city. In all over India, the CRPF base is outside the city.
I'll give an
Give an undertaking in the form of an affidavit that you will go with.
I will give an undertaking. I'll give an undertaking.
Give an undertaking. It's a form of an affidavit. You justify then.
Technically, it's only this, my lord.
Yes, please.
Because he has relieved from this place, he has to submit this application, this money for. One thing we can consider that we can direct this, we instruct these officials, may consider sympathetically. That's it.
These are the directors not to relieve.
They already relieved. My instruction is already relieved.
These are directors not to relieve. It's that they are.
But my instruction is on 25, 2026 is already been relieved. If my learned friend is saying so, then I let him keep it
You
to.
keep it tomorrow. You
Tomorrow, yes.
Instructions and give it to us.
Yes,
And,
Yes, yes.
Is your client also to be ready for that?
Yes, yes, I want only 2 months for the
That
opportunity.
part also I will take.
What is there that no interference with the transfer?
Yes.
The only thing is that the joining at the transfer force is
Only after 2 months.
prolonged.
Yes.
Yes, yes, yes. Only that one.
Is only the prolongation, nothing more.
I will take.
Quickly list item number 1.
Refunds. Refund of an amount.
Yes, sir.
What is the amount which you have taken?
My lord, 5 lakh.
Oh, you have surrendered.
Yes, I have
They have accepted.
Oh, my lord, they have accepted. They have remained silent and asked me for certain documents which I have already submitted before the OP number 2 personal. And after that they have not taken any action. So again, I have.
This is the sir.
No, that is not the fact, sir.
That is not a fact.
No. That's it. Kindly come to the medical document they have submitted. I am.
No. Question is, the question they wanted to surrender. This is the query permit or what?
That's a sandbag.
So they wanted to surrender. They do not want to continue. Now that is permissible under the FRC rules.
I think that period is also over.
So in that is when will you not either reject or allow, will you not take a decision?
You have already taken a decision.
Where is that decision?
Let's say kindly turn to page 19, annexure 5. Page annexure 5. Page
That
9.
is what he is saying. He has already submitted those documents which you have asked for.
No.
That is what he says that you wanted him to appear.
Yes, but
He said that I appeared and submitted all the documents, but you have not taken a decision.
No, he has not
unable to. Yes, well, unable to appear.
Yes.
Unable to appear, but he has provided all the information which you required.
One document he has yet to provide me. I have got the instruction now.
Then have you communicated?
Communicated to him. Where is the communication that what document you give? You have not given this document.
He has said that you are bedridden. Yes, my
Does he see that?
He is bedridden and unable.
What is the date today, sir?
Millet 25.
And what is the date of this letter?
That I received now.
Give.
Yes.
Your authority is playing smart game.
Millet this today.
It is, now we are at 12 noon.
Yes, please. I got on WhatsApp just now.
12 noon, when it is signed. Was the after 10, what is the working hour when it starts? 10 or
10.
so within 2 hours, today itself we have issued and given a letter to him. How?
No, Millet. In this regard, a letter communicated to Sri Agarwal, right, letter number 1043 on 29/4/2026. 29/4/2026.
After 3 years, you see, come to page 19. Have you stated that? Have you asked him to furnish such undertaking?
No,
Then, after 3 years, you are seeking for.
Millet, on that occasion, Millet, we directed him to appear. And Raksik will find at page 21.
Sir, who is a great leader, he is not permitted to move, he
Will I-
cannot move. Will you not? If you do one thing, then he will provide you all the ambulance facilities, the stretchers, the medical assistance. You will be taken in that way to the office. Then definitely.
May I so
You want even his personal presence? We will go. It's a bedridden person.
No, Millet, not that. Lordship, that's why I'm taking to your Lordship for a
Sorry.
medical document, Lordship. Kindly see, Millet. Because here, Lordship, page 10. Lordship, kindly come to page 10. The age of the petitioner is 34, Millet. He was advised
So
for
do you think that the life is very predictable?
He was advised for 3 weeks, Millet.
Come to page 21.
Yes.
That is in year 2023. Right?
Yes.
Come to that paragraph. Last word content.
I requested Board Office to refund the amount 5 lakhs.
No. The previous. That fact remains.
In the meantime, my client is bedridden condition and unfit to travel as he is suffering from acute low back pain and he has been advised by senior specialist take bed rest for a period of 3 weeks.
Then next page. That item was delivered at your place.
On 8/7/2020.
23. Thereafter, what have you?
No, thereafter
Yes,
there was a
Don't go support such a, I would say,
no,
I'm a very bad.
I can't support that also. Once he submits that document,
Yes,
immediately
he said that whatever document you ask for, he has submitted something which is not reflected in that acquisition letter. How they anticipate that what is playing in your mind?
that is in 2026 we have communicated.
Sir, he submitted the document. Did you immediately revert it back? Saying that I want an affidavit, one more affidavit?
Because within that.
Where is the document which you have sent?
It is only to save your skin from paying the interest. This 26 letter.
There was an
This
audit.
26 letter is that.
Only the audit start.
After 2023, you have taken steps in the year 2026 only not to pay the interest. That's a scheme.
Submit that immediately.
With interest.
By post.
With interest, and the interest would be paid by a particular officer who was in the helm of not to burden the government exchequer.
That's public money.
No, the public money, no, that's why we are saving the public money. Not from the government exchequer, but from the personal pocket of the officer.
You to audit
No,
Now you are
so personal expenditures are audited. Tell me, Mr. Tripathi, you are talking about your personal expenditures are audited. You are a salaried man. Pay,
That's why grant us 2 weeks time.
pay from your own account.
15 days time.
Item number 2.
Yes, madam.
With Mr. Lordship. Now, the Lordship, I only request for and sought adjournment because of for the illness of the petitioner. For the illness of the petitioner, and
You are the counsel, you will argue. Petitioner is not coming and arguing.
this matter is listed for
Oh,
the
you have
first
not received the appropriate instruction. Or not
necessary instructions are
Expected.
required to be taken for this. So,
expected. Within short time.
sought adjournment. Sought adjournment.
Two weeks is sufficient. Ensure that.
Yes. Where is a you execute? Why? They have been declared, you have approved everything. Why you are not doing it?
Dates of, that short adjournment.
Day after tomorrow,
Applies, madam.
or keep it in the next week.
It is only.
Very tough.
Consider that the prayer is very innocuous.
Yes.
Item number 4. Item number 5.
Right, we
Why?
have
2 weeks.
Item number 6.
I think your lordship shall be pleased to deal with the identical matters where notices have been issued. Short point here is, there was an auction notice.
You wanted a rectification or a rectification, what?
Your lordship are in session of the similar matters, but here your lordship are pleased to issue notice on that. But here certain developments.
No.
have taken place.
You wanted a ratification or rectification?
No, that's the case, not.
Ratification.
The reason being, it's like this one. Read then.
Where is annexure 6?
Query lease, below it is for a period of 10 years. Subsequent upon
This
being
land
highest.
belongs to Sri Jagan.
The query belongs to Sri Jagannath and sub-collector on behalf of Sri Jagannath temple issued the auction notice. We were the successful bidders. Thereafter, lease deeds have been executed from 2022 to 2032. After execution of lease deed, we are operating it. But it the entire lease is interdicted. This particular lease, but the source of this whole auction was interdicted by a judgment passed by this honorable court, where an auction notice was challenged, issued by the sub-collector for this honorable court, and this honorable court passed an order, coordinate bench, saying that sub-collector is not the competent authority under OMC rules. That's the reason the auction notice in that case was set aside. I mean, first. But in that case, lease deeds were not executed, only auction notice was challenged. Here the lease deeds have been executed. But the question is, in the meantime, certain developments have taken place. Where the mining officer, considering the fact that we have deposited money, we are operating it, lease deeds were executed, mining officer has recommended, after it was transferred to the mining officer, 2024, the whole thing is transferred to mining officer. Mining officer has recommended to the government to allow us to operate for a period of 1 year. That document is here, we are bringing to my lord's notice. So the government is to take a call on this. The lordship will just see it. Page 12 of these blood. Kindly see, referring to Rule 64, the mining officer has written a letter to the government. Can I just place it?
I'm thinking of another principles or doctrine, which I was thinking of. There's a de facto doctrine. Or it's called a factum valet. What?
Hence, but this is a letter, page 12, minute of this today's affidavit, page 12, dated 13th of May 26. Mining officer Minor Mineral has written to Deputy Secretary to Government, para 13, page 13, your lordship would kindly turn. However, as per supplied information of Sri Jagannath Stone Quarry Owners Association, TAPAM, after verification of records at our end, we found only 6 numbers of query leases as per Annexure 1 below, for which necessary government dues are deposited in advance for further 1 year of operation, and which holds all statutory clearances for operation except the temporary blasting permission, application of which were rejected by the collector so by later dated 23/9/20, which is another challenge here. These queries were not included in the past tender notice dated 7/7/2018, notified by sub-collector Khuda, and hence, in the interest of government exchequer, those may be considered for extension of queries for a further period of 1 year, if necessary, by invoking Rule 64 of OMC rules, or alternatively deposited government dues will be refunded to the leaseholders as per the prevalent applicable rules. I think the refund principle here has been taking a view on that. But this extension, mining officer has requested the government referring to Rule 64.
In a disjunctive manner.
Yes, Pranav. It's for the government only, because they have accepted from us and lease deed was for about 10 years, only equity.
Are you serious in accepting this proposition? Or you want to ponder upon that principle?
Let them take a call. We are all people.
I gave some clue to you.
Yes, de facto minute. I have got it. I'll enlarge the point. Enlarge the point. Of course, not today. If subject to the coming back, I'll enlarge the point.
Jagannath Temple is nothing to do, has nothing to do with this.
I think Jagannath Temple is a former party. We have included them as a party.
The administration is not made party.
We have made this.
No.
I think OP number 4 we have. And blood vessels.
My only request is maybe my last, because this present query has been cancelled by Sri Jagannath Temple Administration. Let the notice be issued to them also, because it has been cancelled on 29/11.
Mrs. Das will examine.
Ever.
This has not been cancelled.
Consider that aspect.
Yes, my lord.
If it can apply.
Yes.
Two principles which I believe is the de facto doctrine and the de facto doctrine is also. When are the result of that?
If when item 12 is sent, so item 12 is sent, item 12 lease has been cancelled.
Day after tomorrow?
Yes. Mr. Day after tomorrow, both these matters, Lord. This is item number 6 and 12.
Or next week, Tuesday.
Next week, Tuesday.
That's an item 12. You know, senior is saying the same matter.
Lease is cancelled. That is only
Lease is cancelled. But yes,
Question is, here the point is, the option was there. Participation is there. Decision was taken, approving or adjudging him as the competent person. This gives you an agreement. Yes. Now, subsequently, it was found that the person did not have the pass. Then, consequently, you have cancelled this. Now, only question is that all those actions which he has taken before the declaration that he is not competent, whether those actions could be saved by this doctrine or will get obliterated. So if can be saved, then your cancellation is also, because it is based on that. That will go.
Action done in good
De
faith.
facto doctrine has its applicability so far as those, suppose a post is created. The person who is posted in that particular post, he passed several orders, took several decisions. Later on, it was found that his appointment is defective or is wrong, is illegal.
Appointment would go.
Then what would happen to those decisions and orders which has already been passed? Will it get automatically obliterated or effaced or get cancelled, or it will be saved by virtue of that license?
That was usually.
Yes, this is the de facto or a factor valid doctrine. That is what I was just thinking
Yes,
about
yes.
it, whether you can apply it to that extent.
I'll definitely try. Maybe sometime Tuesday next week, no?
and another copy will be served on the council appearance for the Jagannath Temple administration because it is
It's
something.
not the copy.
We'll do that. We'll do that.
Who is appearing?
Mr. Swai
Mr. Swaggy.
will do that. There's
Announcement.
Mr.
Announcement.
Mr. Announcement.
This normally appears for the Jagannath
Jagannath.
administration. The district director served as office. Whether it is strictly applies or does not apply. Let us see.
Item number 7.
The 12 also is covered.
Yes.
This matter, almost 26601 of 2024 area. Finally, taking this matter along with WPC number 266.
Why we should get
Same
we'll take up this matter now.
Same relief, your lordship. Same relief. Same
Maybe. That would follow the decision he taken here.
Sorry, your lordship. Another dead set has not been filed in this situation. That's why.
Say that you are not ready, you want an adjournment. Don't put all those excuses
Same
there.
relief is there. That's a.
No. It's very difficult to tap the matter because
Same
ultimately it
relief.
is found.
Same
This
relief.
matter is something different. If we don't take, then you just give, it will appear just after that, but not to be tapped. Unless we look at the file. Adjournment of 2 weeks, 1 week, 2 weeks.
I am asking for opinion opposite on copy not served.
Next year, what is it? It appears for the Union of India. It submits that the copy of the reproduction is it says directed to serve the common force and this. Next year.
Item 8.
That's absolutely your lordship. Able to find a dead set. Not enough.
These
The remaining period, lordship, the judgment, they are also lordship, judgment is there. Remaining period, lordship, judgment is there, lordship. Due to NGT lordship, intervention of NGT lordship.
Rule 64.
There are also other matters you want to have all this stuff.
Item 11.
See, it's a illegal extraction of sand from the river Daya miners. We are the affected villages.
Or you are illegally extracting.
No, we are not illegal extracting. We are the villagers. And some sand mafia are illegal extracting.
What are you doing, sir?
We have submitted their.
In fact, Mullah, they have given a representation at page 7, Mullah. I have talked with the manning officer yesterday, Mullah. They are looking into it. Very soon, Mullah, their prayer is only for representation disposal. That's
Yes.
done. They say the illegality are found, Mullah.
That will not really create any.
No, Mullah, we are looking
We
into
wanted, I take this very frankly, so far as I'm concerned, if it is the case of illegal extraction,
yes,
without any license or.
Mullah, we'll take absolute action.
Nobody in the orderly society will ever accept that illegality should perpetuate or.
Mullah, if
We have to pass an order for that, that will have to take.
if illegalities are found, Mullah, obviously, Mullah, the state will take immediate action, Mullah. They will
Take an instruction whether this extraction is
yes,
by
Mullah.
a rightful person. Or is it?
It should be very dangerous. And the.
Closing of said to
The bridge.
Bridge also, yes.
So that casualty.
My lord, may keep the matter to the next.
That's why. You are keeping this matter on next Tuesday.
It is happening in a continuity report, Lordship, just to have 500 meters from this institution every day. The High Court of Orissa and report it is going on.
Or extend the period so that we can mine the sand.
Where is the provision for the
60 comes in 64.
the state government?
The representation be considered.
So that will be another source for you to. Same order 64, move 64 to consider, or in the event they had decided, then 2%. Something. Disposing of, we are not going for a representation.
Item 14.
Except 4 is already there.
Item 14, well.
14.
Yes, 1/4.
Lordship, here 14 and 15 both have similar matters. And perhaps it is also Lordship covered by Lordship judgment. Lordship can order passed by this Tahsildar. Lordship after amendment of this act, Lordship. He has cancelled the.
Yes, Mullah, it is covered, Mullah. And there's already, my lord has already decided the issue. But here, my lord, the conduct of the petitioner, my lord will see. Lord, the Impune order, it was passed.
However, does it change the law?
It does not, my lord. But, my lord, I point out.
Evidence is under challenge. Yes, we are, but we are bad.
My lord, it was passed way back in the year 2023. Thereafter, my lord, he did not challenge it.
So within 3 years,
he
he's coming
prayed
for
for
us.
No, he came before this honorable court. He prayed that my security deposit, which has been forfeited, that may be released. This honorable court directed you people to file an appeal as per Rule 34. They filed an appeal. They withdrew it thereafter. Again, they came before this honorable court. Another writ petition that was also a withdrawal.
Because of lack of jurisdiction.
No one can make
And perhaps has understood this order, let's see. Where I have come now, you should understand from the content of this appellate order.
issue
He
is
has not
already
given
decided.
liberty to raise all those points. Lordship, the appellate authority did not allow me to
Point
file
is-
such application. Because I ought to have been, Lordship, given to his knowledge that in the meantime the judgment has come up, this is without jurisdiction. He did not allow. That's why this writ application.
No, that
You
is
should
not what I'm saying.
understand the
I'm
content
saying,
of
my
the
lord,
application.
says that, my lord, this
How can you say the
order-
content?
That's not mentioned.
Well, that part says.
Item 14.
This one.
This.
Both the cases, Lordship,
Item 14 and 15.
13 and 15. And Lordship, I have
16 adjourned.
one other.
16.
16 already.
14 and 15.
Item 17.
Lordship, one additional prayer, Lordship. Within my prayer, Lordship. If I'm succeeding, Lordship, the complete constitutional action should be proceeded, Lordship. Lordship, nice.
Item
Because constitutional, again I have come, Lordship, again I come. Lordship, like that.
Item 17.
Because I'm challenging the demarcation of an approach road for a sand quarry. Yes. Wanted these two letters. Who are you? Well, I am a boundary tenant of the road, which is I first time this word is known. This has come. Boundary tenant. Well, I do not know. I am in possession of the neighboring plot. Maybe you are an adjacent owner. I guess as a boundary tenant. But my short point is that the demarcation has been made without following the due procedure. Go and challenge that demarcation. Yes, sir. Well, may kindly see Annexure 2, page 16. Well, at the time of the demarcation, that was done. Did you raise it was done without issuing any notice to me. Maybe whether you had a knowledge. No, Melons. It is my specific government that I did not have any knowledge. Your Lordship, I only see the provision. Annexure 2. Annexure 2 are the guidelines issued by the Revenue Department. Is it an enforceable guideline? Well, it is an executive instruction or it has any flavor of law? Well, it is a guideline, but it has to be followed. Is it executive instruction that it is not legally enforceable? Well, if they are deviating from that guideline, then they have to provide reasons. No, that is they can deviate from it only in public interest. That is their internal mechanism. That does not give you a third party a right. Well, to legally enforce that. Malice will kindly see page 17 for a moment. Page 17, paragraph 3b. For a moment, Your Lordship, miss. Page 17, paragraph 3b. Each voluntary application for demarcation filed by a party shall bear the prescribed process fee. Upon receipt of the application, the Tahsildar shall open a demarcation case record, enter the details. Then Your Lordship, then he shall issue individual notice to boundary tenants inviting objections and fixing a date and place for hearing. The notice, then Your Lordships will see over the page. All boundary all boundary tenants shall be intimated the date and time of demarcation. Then paragraph 4c, at the time of objection hearing, if the boundary tenants object to demarcation, the Tahsildar shall consider the objections and shall pass order as he deems fit. In case of rejection of the request for demarcation, the detailed reason of rejection shall be recorded by the Tahsildar. The source of this document. Well, this is a guideline. This is available. Well, this is a guideline. It's based on a principle of natural justice. I understand that, but if you want to enforce, then you have to show that it is a legally enforceable document. It is their guideline that they have to follow this procedure. I'm talking in the sense of the judgment of the Supreme. And in the present case, all they issued was a public notice. That's the case of a Nasli Wanya. Yes. There the guideline was issued. And they wanted to take advantage of that guideline, saying that the authorities cannot depart. The export says the executive instruction has no legal statutory flavor, not legally enforceable at the behest of a third party. But when a procedure has been provided, for them to deviate from the procedure and violate the principles of natural justice. Same thing is with the land manual. Is completely an internal mechanism of working of the departmental things. Not third party's right is not created with that.
Well, let's let them at least let your lordships may relegate me to the authorities. Let them consider my objection at this stage. Because the right has been provided for my objections to be considered in reason order to be passed.
You have already understood my
Well,
stand in this regard. Totally against the consideration of representation. Unless I find that there is a legally impossible right in you.
well, it's it is a guideline which mirrors.
That's why I'm asking. Please show me that
it mirrors
the source.
It is not a mindset provision.
What is the source of this guideline? Any statutory provisions are there where it permits any kind of a SOP or guidelines to be made by the authority?
Well, this is statutory in nature.
If there is no source of power, then it is merely an internal mechanism for their smooth working of in the department. But it does not create any third party's right to enforce it.
Well, my right is created
This
because
is what I really wanted.
Well, it's when I am in possession of the neighboring plot.
I understand.
Well, there will be trucks going up and down in front of my house.
You have to assert your right somewhere else. To claim that you have acquired the absolute right of ownership aspect of a property and they cannot encroach upon your property.
Well, it is not the demarcation has not been made of my property. Well, I am right adjacent to the property which has been demarcated.
Sir, if by virtue of this demarcation, if any of your property is diminished, any of the property is being included or subsumed into that particular land the road, I can understand then you have to make up a case of the nature. Asserting that you have a right of ownership. And this is what an encroachment has been made on your property. Well, I can understand those kind of cases. But here you are saying on the base that you were not noticed, that was not given. If your property is not affected, why you will be given a notice?
Well, because my property is affected because I am a boundary tenant. Because
there is an encroachment on your property, then you have to make out a case of that.
There is no encroachment. That's a case.
If it is not, if your property remain intact,
yes, sir.
Then in that event, if some movements outside your property is done, what is your right?
Well, it's when what is
your right?
Well, it's the road.
Then, according to you, these guidelines are there. Then everybody, suppose the road is sought to be made on a southern side of the property, and the adjacent boundary one, who is on the northern side, intersected by a property of a third party, will come and say boundary tenant, boundary to that property which has been demarcated.
Well, these guidelines were
how you are affected.
Well, these guidelines were issued exactly to address these issues.
Please read the Nasri Wadia's.
Yes.
And I think there are multiple judgments on that score.
Your Lordships may have this matter tomorrow.
Read that. That was in relation to a public, eviction of a public property.
Yes.
PP Act.
Let's hear these guidelines. The first paragraph of the letter itself says, I am directed to say that numerous grievance petitions are often received in the department regarding demarcation proceedings, disputes over boundaries among the tenure holders, creation of new plots due to partitioning.
The Amin has gone there and he has demarcated the property. What more?
Therefore, when the procedure is provided, that they have to give me a notice, an individual notice.
What?
The all movements shall be estimated the less than time of the demand. He is saying that.
But this is under the guidelines.
That
is the first thing is that I have understood, but that is the first thing that whether guidelines has any statutory recognition.
And your Lordships may kindly see,
in line of law.
Your Lordships may kindly see Annexure 3, the notice that was issued in the present case. I was not aware of the notice. Secondly, your Lordship will see no plot numbers are even mentioned here.
Question is on, you are talking about a principle of natural justice.
Yes, sir.
Now, it is not an abstract principle.
Well,
now, the evolution has taken place in the form of a prejudice. I am talking about what prejudice you will suffer by not giving a notice. Prejudice means that your property is either being encroached upon, your property is being dissipated, your property is being destroyed. I can understand some kind of situations. You are saying no encroachment, no, nothing of that kind. but I am entitled to a notice. Why?
Well,
What
I
is
have-
the prejudice?
well, I have to-
I just wanted to understand. This is, I was not going so clearly, but this is what is playing in my
Well,
mind. Prejudice.
there are two prejudices in the present. The first prejudice is there will be large mining trucks which will be running on the road right in front of my
mining truck.
dwelling house.
Your land is going, your trees are going to be affected, your trees are going to be a fruitless tree.
Secondly, well,
If it is a fruit bearing tree.
secondly, well, the road that has been demarcated, the new road that has been demarcated, they propose to demolish a structure. It has been described as a structure in official documents. The structure is
Only
actually
the
the
second letter, the second letter says that there is already a substation or something kind of
and a structure
which obstructs. So they have said that please take an appropriate action. It may be that particular substation may be shifted nearby or somewhere else.
It's not about the substation. There is also a temple on that
beneficial aspect to a large section of the society. It is within the domain of the government. They have to take a decision. If everything is controlled by a handful person, I think the democratic setup would collapse.
But Melis, I had a right to be heard, Melis.
What is your right? That's why I'm saying the question of prejudice. You are not being able to say you are the owner of a particular adjacent plot of land. Tell me that how your land is affected. Whether the area has diminished, it has subsumed into a road without any initiation of proceeding. Appreciate.
Is the amount of pollution that will be caused
there? The pollution control board is there. They will take care of that. Then in every event, no road will be used for plying the vehicle. Should not. Then we should discontinue with the road because it will create a pollution.
But they have to examine whether an alternate road can also be provided.
Simply, the road is constructed for the purpose of plying of the vehicle. So, do you say that no vehicle should be plied, road should be there? What is the utility?
I have no objection in respect of normal vehicles, but
what is the distinction between a normal vehicle and an abnormal vehicle?
Where heavy vehicles are being used for
the roads
for a polluting activity.
Then in that event, the highways and all, everything should not be allowed. There will be a large number of the heavy vehicles that would pull up. Then there should be a separate dedicated corridor for a heavy vehicle. Very appreciate. I appreciate it. Everywhere across the country, it has to be a separate corridor.
Your Worship, I have this matter tomorrow. I'll examine the guidelines.
Is it a way?
I'll examine the enforceability of the guidelines.
To us. Have you got like Naslivadiya judgment? Obviously by Justice S.B. Sinha. NUSLRE translate Swadia. Spelling is the only one. Or NUSLR.
This is AIR 2008 Supreme Court 876.
Yes. The 2000 SB Sinha.
Yes.
SB Sinha and Justice Harjit Singh Bedi.
Yes. It talks about executive instruction.
Let's examine the proposition that even where a provision is directory, then also it has some persuasive effect. I'll examine the provision.
Not even a single judgment.
I'll examine.
Leave for your satisfaction, leave, but
Your Worship, I have this tomorrow.
no. At least I can share that I have not come across a contradiction. So it would be a Herculean task for you. Look at that proposition. Actually, this cannot be done in this.
My only prayer is that my objections may be heard.
What prejudice I have not seen any prejudice as of now. And this is the very far-fetched consequences, what you are talking about, the movement of the heavy vehicles. Then the heavy vehicles should not be manufactured in India. They should be always a small.
They can examine.
You understand that it impacts the economy as well.
Yes, they can examine.
Inflation will also rise to a great
They can examine. They can examine an
alternate. Carrying in a smaller vehicle, then amount of cost they have to suffer. Do you realize that? Some rationality. We can't go and interfere in every public policy or in case of any policy decision of the government, which is for a betterment. You go through that judgment and just thinking, but I do not think.
Item 18.
Yes, paragraph 23.
23.
It says issuance of such guidelines, however, is not being controlled by statutory provision. The effect thereof is advisory in character, and thereby no legal right is conferred upon the tenants.
Look at it, the language. You can approach the court provided it is a legally enforceable right. Well, if it is not, then how can you?
These guidelines are merely to enforce
They are
merely to enforce the principles of natural justice.
That is what then I said the question of prejudice is also very important. Yeah, it's not an abstract principle that the natural justice. Even a person in another country expects, no, I should be given a notice. Classical approach. But that's why the concept of prejudice has, but then what prejudice you suffered? Suppose if you are given a notice, what? Suppose if you are not given a notice, what sufferance you have? Prejudice. We are trying to fathom upon those, that whether it is a prejudice, we have not been able to say a single sentence where I can find that you have made prejudice.
Yes, even in cases for major mineral things, before an environment clearance is granted,
right to property is affected, which is a constitutional right. We appreciate.
It's my right to enjoyment of my property is affected.
Where is the fetter in enjoying your property?
By degradation of the quality of the area.
Every adjacent plots where it is for a housing sector, you have already constructed at the first, and later on the adjacent owner wanted to construct. There will be some kind of the task that would come. Say, why it's a right to enjoy my property. How can you make no construction in the adjacent plot? See,
even
acceptable, sir.
Because this is a case which involves the quarrying area. Even in cases of major minerals where an environment clearance is granted, there is a large number of conditions that come with the environment clearance.
True, if those you have not been able to make out a single case of that nature. Again, I am saying, if they are doing the mining or quarry activities strictly within the parameters of law, then you cannot put any question. How can you? Then you have to make a case that this is what a condition they are violating. I can appreciate it. That is not your case.
Just as for an environment clearance, a public hearing is necessary.
No, that is then you have to challenge that particular clearance which is given to him.
Yes,
you have not challenged the clearance.
Yes, I'm not challenging the issue.
Then you are based upon a case that since this guideline is there, which says that a notice is to be given to a boundary tenant, the notice is not given. First pertinent question, whether this guideline has any statutory force.
It's a non-statutory guideline.
That's all. Then whether you can legally enforce it, that is what the judgment says you can't. Then what remains in the then we are disposing of this.
Very well.
Here and now. Give me that judgment. The instant petition is filed.
I think though I have a limited prayer, but my learning paid for the government side, he
has expanded it.
no, he has forwarded the copy of the order filed on my representation.
Okay.
So the cause of action does not survive any.
Okay. It is submitted by the council appearing for the petition.
Item number 20 lodge to be permitted to withdraw the writ application with the liberty to file a better application. This is a requirement.
And we should also receive the same fate.
No, you lodge actually by inactivity and have
We should receive the same fate. Or a better application will receive the same fate.
21.
Provided High Court of Siddharth Mishra, pay for an adjournment number.
2 weeks.
Item 22.
Here we are challenging the order of the ADM in rejecting my appeal.
Order of
the appellate authority DDM.
Yes.
6 minutes, page 68.
Yes.
In rejecting my appeal on merit in my absence. Lordship may look at the page 68.
Why you did not appear?
Yes, madam. Page 69 is the order, my lord. I have filed this appeal on challenging the original demand made by the manufacturer for rubber extraction.
Yes.
On 16/12/2024. On the next day, the first date was fixed to 25/2/2025, wherein I have orally prayed before the DDM to provide me the assessment reports on which the calculation for rubber extraction has been made. On the next date, that is not the date wherein the appeal has been dismissed in my absence without providing the documents or the report.
Please further.
Was it perhaps for instruction grant some time or after instruction?
Next week. Take instruction.
Not what I filed and I am not possible to this.
Let them come in the next week, sir.
Item number 27.
This is the trust exempted from Income Tax Act. And there is a certificate, subsisting certificate, which is at page number 59. For a moment, turn to page number 59 for a moment. This is the certificate issued to me with effect from the 2016. And prior to that also, I continue to enjoy the exemption. However, only for this year of 2018-19 assessment year, they have taken up my original return instead of the revised return, which I filed within the 1 hour of a mistake that I did. I filed a return on 30th of September 2018 for the assessment year 2018-19. I committed an error by not claiming the exemption. Giving all the figures identical, I immediately within 1 hour, I filed my revised return in consonance with that of the audit report, which is actually in sync with the exemption recorded in the audit report. However, what happened in 2019, they initiated the proceeding, the scrutiny assessment under section 143. And then the order was passed in 2021. Upon receipt of that order, my appeals are appropriately challenged under now pending before the appellate authority. That's a Commissioner Income Tax appeal. Section 246A is pending. That is on, there are 2 orders. One is the penalty, the assessment order, 11 crore
50 lakh on the income of total income of 23 lakh, out of which my taxable income is only 25 lakh as per my revised return, and I'm only eligible to liable to pay only 8 lakh as a tax against the 25 lakh. However, in the scrutiny assessment, they denied me the entitlement of exemption and then raised the demand of 28 crore. One is 11 crore on the assessment order, 17 crore on the penalty under section 278. So why this impugned demand they have raised in the August 2025 over a span of 5 assessment years beginning from 2017-18 to 2021-28. Now in the reply they are admitting that out of 5 only they are concerned with only one assessment year, that is of 2018 and 19. Pre to 2018-19 and post 2018-19, I am always allowed the exemption under section 12AA. They say just because there is an exemption, it is not automatic. And the assessment order, if your lordships want to see the merit, page number 139.
And what happened to the appeal, which is pending?
There's a faceless assessment, the proceeding is going pending. My request for a hearing is not heeded as yet. I've given my written submissions also. They were supposed to pass an order without disposing of the appeal proceeding. What they have done is that they have issued the garnishee notice, ignoring my September 2025 representation saying that my appeals are pending. Wait till the disposal.
Did you comply with the statutory mandates of the appeal? Did you approach the authority for staying the demand because you have already gone?
Correct, Lords. Lordships may see that 17th of September 2025 letter, which is at page number 207 for a moment. That is where I have requested, pursuant to this impugned demand of August, I approached the authority on 17th of September saying that please stop it, stay it because my appeal proceedings are pending, which is at page number 207. They did not respond to that. They immediately thereafter, that is September, post September 2025, they issued the garnishee notice under section 226(3). That is at
keeping that application pending.
Yes, everything is pending there. They still, without heeding to my request.
Yes, a request for stay is also pending.
Yes, it's pending.
What are you doing? Decide it.
Yes, no, my lord, I'm just lying. What happened in this case is they have this 18-19 assessment is relating for my lord. It is a function of 5-6 years. And against the 18-19 they prefer appeal. They didn't find any application for stay, anything before the appellate authority, only they filed appeal.
No, it is not necessary. It has to go to the
assessing
officer
under section 220
yes.
bracket 6.
Yes.
He is to reply. Mr. Mahanti has to reply.
I'm just clarifying.
Whether that is pending or not. That Mr. Mahanti will clarify.
This department is giving me all this instruction. My brother will assist you all this. What instruction they have given to me? What they are saying that they before feeding the same, they have given sufficient communication to them. They have not responded anything in this regard.
The question, Mr. DSG, is simple. They have a statutory right of an appeal which they have exhausted.
Yes, then
Now, so far as the appellate authority is concerned, there is no provision of law there that the appellate authority would stay or pass an order of stay. They have to approach the authority under section 220 of the Income Tax Act before the assessing officer seeking a stay because they have gone for an appeal, deposited the statutory amount which is required to be deposited for an appeal. Appeal is not incompetent. Now it is the duty of the assessing officer to decide. They can impose the conditions, either granting the conditional order of stay or they can give a blanket order of stay also. Now the question what he is raising is that I have approached all the authorities which is provided under the law. The authorities are keeping silent on each occasion. They are not deciding my case.
No, man.
Show us, that is what I say, whether first thing is his appeal is still pending. Has it been disposed of? No.
The appeal is filed by them and it is pending.
Now there is no dispute.
That is for all assessment here.
Or we are not concerned. We are mostly concerned because the assessment imposition has been done only in 2018-19 assessment year.
Yes.
He is saying that previous to assessment year 2018-19, he has got the exemption. even posterior to 1819, he has got an exemption. So he's not disputing any kind of a adjudication or the assessment orders passed subsequent thereto. He is concerned with assessment year 2018-19. His case is very simple. He says that I have got a certificate which permits me to claim an exemption. Due to bona fide mistake or oversight, whatever, he has not claimed an exemption. He uploaded the return immediately within 1 hour after detecting that this mistake has been committed. He uploaded a revised return. Now, authorities have proceeded to decide and impose they pass the assessment order, making him liable. He has gone to appeal. That is what his case is. He has also approached the assessing officer for stay. Assessing officer has neither rejected nor allowed. Now, what is this?
That is not forthcoming from his objection. Come to page 5.
Yes, 5.
Come to page 5 of your objection.
Yes. Yes.
Who has filed this objection? Mr. Manti, have you filed or?
No. The instruction given.
It is further submitted.
Nothing
is coming out. They are not.
Whether it is pending or it is disposed of. Tell me.
So
220 application.
So I am drawing your attention.
Is pending. 220 application.
Yes.
That is not.
Then how can you go for a garnishing?
It is a consequential of more than
Sir,
they are confusing with code. What I am saying, they are first there they have the release of one account in respect to the seizure. Another pair they have in respect to the assessment year, what he has filed an appeal and we have taken action without giving opportunity of hearing to them. It is not
faceless. It is all the faceless manner which is now provided.
Yes.
If it is a faceless one, they are not supposed to seek that. What they are now saying is that I'm not. I have uploaded all the documents. I have uploaded all my arguments. Now you have to pass an order in a faceless manner. So that you have not done it as yet. Secondly, main important thing is that 220 application is still pending. How can you proceed and initiate a garnishing proceeding?
For a moment, can you
garnishing? Have they directed any of your the debtor, the creditor to debtor to pay you?
No. 22 bank accounts are frozen.
Your bank account. Then it is not a garnishing proceeding.
The garnishing notice was so far as the 226 things.
Sorry, the garnishing noticing is something different. Suppose if you are entitled to receive any payment from a third party,
subrogation, and
then they can initiate a garnishing proceeding, saying him that don't pay to him, don't pay to me.
No, they have. No, this is also in the nature of the garnishing notice because they have directed the bank and the bank has already deducted that amount. They have already got.
That's why in the objection paragraph 7, let me see for a moment. Paragraph 7, for a moment, let me see.
Yes.
We are explaining this.
Objection. In objection.
Series of communication. Yes. Objection. Paragraph 7. For a moment. The series of communication dated 2/1/2025, 17/7/2025, 12/8/2025 as the requirement of issuing, calling upon the petitioner to liquidate the outstanding demand against the 41,22,77,597. The petitioner was specifically informed that my disagreement regarding the demand should be communicated to the department despite repeated opportunities. No substantial payment was made and no objection was filed. The attachment order under 26/23 was therefore undertaken as a measure of last resort for the portion of government revenue. Then Narasimha, my lord, Justice raised about the page 5. Then next, the verification of department records reveals that the petitioner has communicated operating the bank accounts bearing such a number. Then there is a suppression of fact. Then Narasimha comes to paragraph 3. They further submitted that the petitioner had filed an appeal only in respect to the assessment year 18-19, and with demand of such and such 11 crores, 44,000 lakhs, out of the 40 total amount of 41 crores some odd. Then, however, despite filing the appeal, the petitioner did not obtain any stay of demand of the appellate authority.
So that is what you are not granting. Sorry.
So,
that is
now,
what is-
suspend what?
that granting of a stay is within your hand. It is not in his hand. He can simply approach the authority that you please grant. You may decide.
In application of that, didn't say move.
Sir, why not you will dispose of the application?
Fix up the date.
Fix up the date for application.
That's why I am praying, my lord. Before that, I get what I am praying, my lord.
I have the limitations. They can't. Freezing order or the garnishee is in relation to 1819 only.
Yes, Lord. Page 6, para number 11.
Of
Their reply.
Reply to?
To my interim application.
Yes, sir. Objection.
This
Your
is
Lordship?
flat.
Yes.
This is flat.
Plan D.
Yes, Lord.
Plan D.
Page number 6, para 11.
Yes, sir.
That in reply to the arguments made in para so and disputed and denied, the petitioner seeks recusable relief while suppressing the fact that only approximately 1990 has been recovered despite outstanding demand exceeding 28 crore. This 28 crore is paid 2018 and 19. That's they admitted. Your Lordship, they see the little higher up.
Sure, that it is only in relation to.
My Lord, better to the page number 5.
Yes. First.
It is further submitted that the petitioner filed appeal so assessment year 2018-19 1144. That is just bear with me with that fact only. Now kindly turn to my Lord their own calculation at their impugned order, that at the page of 205 for a moment. 205 for a moment. 205.
Yes, sir.
My Lord will see this is the 12th of August 2025 notice.
Yeah.
And my Lord may see that at serial number 2 and 3, this is 2018 and 19, cumulatively coming about 28 crore. 16.63, that is section 270A, that is the penalty amount. Then 11 crore 44 lakh, that is actually the assessment order. So both of them are coming to 28 crore out of the entire amount of 41 crore. Now my Lord may also see the top, the 8 lakh to the outstanding amount for 2017 and 18. My Lord, that is actually demand according to us, Lord, there is no such demand. We received for the first time through that demand and we have replied back saying that there is no assessment order is pending in that. Then number 1, number 4, your Lordship may turn to number 4. The outstanding amount is only 10,86,000. Then your Lordship will turn to the 5, 6, 7. They're roughly coming to about 13, 14 crore. This they have already at the page number 204 to see. They have already in December, November, they made it 0. At the page number 204 to see. 204 A, B, C. just above the 205. My lord may see that. 204A. This is the assessment year for the 2009-2021.
Where?
Page number 204A.
No, 204.
That corrected there are two petitions. I have corrected the petition because that they have raised it on the 5th of June. I have given the corrected petition. I have corrected ballots. It's there.
20. It's 20.
Extra copy है क्या? मैंने saw that.
Is a rectification order?
No, there was a
204A.
ABC was not earlier annexed. I have annexed it and I have corrected the indexing and given a complete
Page 204.
Yes, it's a rectification order. Yes.
What I'm asking.
That is at the page number 204A.
Yes.
Yes.
Rectification. Now they have said nil.
Nil. Then if also we go to the 204BC, that is for the assessment year 2011, 21, 22. That also made 0. And rather we were given the refund. Rather, for the assessment at the page number 204C. My lord may see that 204C.
The order what my non-friend is citing of the just now to the report A.
54 order.
154 order. Yes. It is order 2020 2021 and 4/12/2025 order.
Correct. This is November 2025, 2021, 22. They made 0 out of 5. Now remains is the 2.
May this commissioner has asked me for 1 week time to file a detailed counter. So we'll come just.
This has been passed much beyond. Yes.
They took up 4 days during the vacation.
We are thinking that we are directing this assessing officer
to decide
to permit you to go there, sit, give all the documents, let him pass an order.
Absolutely. No problem.
We don't have enough.
And you take notice of all this.
All these you are permitted to rely on all those documents.
And what is remaining?
Yes.
And you ask to.
Yes.
Correct.
It's good problem.
Only problem. Out of 20.
We are keeping this alive. We are not disposing of this matter. We are simply by way of an interim arrangement. We are making
one small suggestion. If Lordship will turn to my page 5 of my interim application for a moment. Just for a moment.
we are not going to. That will pass much earlier.
Out of 22 accounts.
For 1 week, you can, if you have waited for such a long, you can wait for
Just can you hear me out, Lords? I am only a small submission. I'm not asking your Lordships to wipe out all the phrasing. I'm only saying, out of 22 bank accounts, 9 accounts, my Lords, which are linked to the skill development of a Government of India and PSU program under the employment scheme. We are actually doing the vocational training under the Government of India scheme. That's why we are exempted. What the fund has to come through there, then only it can be dispersed. I have already suffered for last 8 months because I tried to chase this. Correct.
And prior to this vacation also you have.
Correct.
During vacation also you.
Correct.
So wait for 5 to 6 days. We are directing you to go before the assessing authority in respect of this petition which is pending under section 220 which you are seeing, or file all those documents and
Let them consider
the current document also, so that he will frame up again, reconsider the entire thing, whatever amount is left, and he will take a decision within 3 days. We will come back next week.
Within 3 days, it's okay. Otherwise, Balot, my all expenditure, because 600 students are studying, 50 teaching and non-teaching staff, 150 teachers are trained on behalf of the government of Madhya
Things are right, but the government is 41 crores somewhat.
Will you allow them day after tomorrow?
Yes. No problem.
Before assessing authority?
Yes. Assessing authority.
Monday, next Monday.
No.
Sir,
No.
since long, you have not been able to
How much?
reconcile.
Yes, yes.
It is only reconciliation,
Yes.
sir.
Yes.
They have to do on 25th. Yes.
Yes.
Extra time.
Because
26th maybe.
Holiday.
So,
25th, yes.
So that you can come back on 29th.
Absolutely. No.
And only we have required out of 41 crores, 19 lakh come out of the.
My brother is more convincing than me. At least he has been able to convince you. I was really breaking my head to convince.
In fact,
the
president.
No difficulty. Now, I think it should set at rest. Let the dictation come and then you go.
Only one small request. After that, your lordships will post it so that at least I don't have to suffer another more than 5 days.
for next.
You're gonna say PAL?
Yes.
Yeah.
Because they are not trying to be submitted by.
For the same prayer, madam. 29 also I'll file affidavit in course of the day. I'll serve copy in course of the day. Madam. File and serve copy.
They was not the advance copy. Saying the copy thereof shall be served upon the applicant for application in course of the.
So there are परिश्रम करतो. That's better. Because my lord has rightly, both my lords have already decided the principle. But the judge has gone to this then. Only the quantum parameter, yes.
Item number 30.
So I will have my lord to file reply something to this end.
First you have a copy of the affidavit and thereafter.
Yes, public.
Item number
And 30 minutes, 2015.
That's the perfect next week, my lord.
30.
Next week.
Item number
30 minutes.
30 minutes. Is this a matter where the water department of water resources had created a water conservation fund, whereunder the using water which was being consumed by the various industries in the state and to pay a certain amount. Now these batch of cases, these batch of
The same message.
And 31.
Answer B.
Yes.
Both 31.
Item number 32.
22 is that reviewing the lordship in the last order.
T2 I request to be senior also. This matter may be taken by senior. I could not prepare myself.
With that document part which your lordship had directed.
Yes, that is there. That is that I have that rule I have.
30.
Next week.
Item 33.
Sir, item 33. 33, your lordship had directed me to file the counter affidavit. Counter affidavit is otherwise ready. It will be filed by tomorrow and copy will be served on the public by tomorrow.
otherwise capable of making an argument.
If we decide the matter in their absence, will it be proper? If we decide the matter in your absence, will it be proper? No. So we have to give opportunity to both equally. Let them file an affidavit. Let's go through it. We are fixing this matter on 30th, as we said, no difficulty. We'll hear you on the 30th.
Item 34.
To prove my own right. Only regarding this is the engagement of senior, designation of senior advocate, my law, as this is pending on the office. And your lordship will decide.
Has it ended with a happy note? Tell me.
Yes.
May I submit in your file? I am appearing for the appeal panel 1, 2, and 3. Study and registry High Court.
I have prepared only brief short note.
Just a minute, just a minute. Brief short. In the meantime, Lord, Mr. Vigyan Mahapat was sitting on the he has not appeared, he has denied, expressed his inability to appear. And Mr. Narendra Kumar Mishra is appearing.
Or opposite party number 1 and
1, 2, and 3.
1, 2, and 3. You are appearing, you will address senior counsel.
My lord.
Mr. Vigyan Sharma refused.
Then
1 to 4.
1 to 4. Sorry, I'm sorry.
And now you want to extend Mr.
Narendra Kumar.
Narendra.
I'm filing it
Sir,
for.
Really good.
Yes, I have told only one point, your lordship decide nothing more. Only the secret ballot has been resorted to. This is the only which against the settled principle of law decided in the Indira Joshi. Only it is only to be decided. Anyway, but unfortunately,
of EMD and the imposition of penalty has taken place beyond the terms and conditions of the notice inviting tender. Notice inviting sale of calibrated lump ore. In the lump ore.
Okay.
So the petitioner is a trader and he was successful auctioneer for purchase of 4,000 metric ton of calibrated lump ore. Due to force majeure, he was unable to lift the remaining unlifted quantity, which was 2,000 metric ton. Now, the penalty imposed on abandoned goods is, as per the terms and conditions, on the unlifted quantity. But the petitioner has been imposed penalty and forfeiture of EMD on the entire. So the council, in the last occasion, was asked to seek instructions.
I have obtained instruction, my lord. In the earlier occasion, Lord Senior Mr. Ratha has submitted that he is forfeiting all other claims. Only he is claiming that at least 50% of the security deposit may be given to us. To that regarding, I was to take the instruction. Because, my lord, I am reading, my lord.
No, then what? Then what you have taken instruction?
My lord, instruction I am taking, my lord. Here, my lord, in this, my lord, in case the bidder do not leave the minimum quantity, unit size minus tolerance limit within the specified period, then the amount of SD for the incomplete units will stand forfeited.
Correct. Incomplete. Let's say that
he was
50%. He has lifted 50% not. Incomplete is 50%. That's why he said 50%.
Percent. To that extent, I have I have obtained the instruction, my lord. My instruction is this is for the incomplete unit.
What is the incomplete unit?
Whatever remains, my lord, because the incomplete unit means, my lord, below unit oblique unit size minus tolerance limit. That means plus minus 10%, my lord. Below that is the incomplete unit. Whatever the incomplete unit, for that security deposit shall be forfeited, and it has already been forfeited. And it is not for the ratio, remaining ratio, my lord.
I have not understood what you
My
said.
lord.
Unable to
My lord, I am submitting.
ponder upon or fathom what you said.
Submitting, my lord. I am submitting, my lord.
Which clause you are reading? Which page?
Sheet 3, forfeited.
Page.
Annexure 3, my lord.
The page number.
Page number 65, my lord. Annexure 3 of the consolidated writ petition, my lord. Page number 65.
Yes.
On the previous occasion, they submitted 6-3, my lord, forfeited SD.
Yes.
In that, in case the bidder, second parameter, in case the bidder do not lift the minimum quantity.
What is the definition of a unit which is given? Well, what I gather, this unit they wanted a lost.
That same annexure, page 15, my lord. Same annexure 3, my lord, 59.
Yes.
Fifty-nine, my lord, annexure 3 of the consolidated petition. First para, there is a table, below table it is written, quantity tolerance is plus oblique minus 10% per lot for road transport only.
Sir, please kindly consider two aspects of the matter. First thing is you are banking upon the expression or the word unit. They are banking upon the expression lot. Now, what is the effect of this? Please come to page 65. What troubles me? First top, unit of measurement for bidding, sale, and delivery. Correct? It is only for the purpose of bidding, it is for the purpose of sale, and it is for the purpose of delivery. What it says, unit of each lot. Have you got lot? Lot may consist of a particular quantity of the poles. So each lot shall have to be bid, sold and delivered on the basis of a unit of measurement is stipulated in the material list displayed on auction floor or view live auction. Any representation, complaint from the bidder for the bid to be made or having made on the basis of any other unit of measurement will not be entertained. This is what they say, that every lot containing a particular quantity of the ores have to be bid on the basis of the unit of measurement. Is only for putting of the price.
Yes.
Then come 6.1 security. The pre-bid EMD of successful bidder will get automatically converted into a security deposit. Very fair. No difficulty. Only the character has changed. From a EMD, it has now become a SD.
Security.
Then, after successful lifting of minimum quantity plus minus 100%, as is specified in the catalog by a successful bidder within the specified time, correct? SD, I think they are wrong. Innovation, it should be comma. SD will be released after
Completion.
it should be a completion.
Completion.
It should be a completion of a contract period. That reconciliation of a royalty / 1 month from the date of the publication of IBM price of the benefits we presented earlier. Then the forfeiture of SD, which you underline. Each unit, please consider, each unit will be treated as an independent contract. Now, what is the meaning of this word unit? Does it not referable to a lot?
Obviously not.
Does it not refer to a lot?
The entire lot is 4,000.
Correct. That is what I'm telling. So if the each unit will be treated as independent contract, the reason is that you may auction the ore in a different lots. Say 10 lots are there. One lot contains 4,000 metric ton, one lot 5,000 metric ton, another lot 10,000 metric ton. If person has been declared successful in 3 of such lots, he can participate. So you cannot club all the 3 lots together because each lot will be an independent contract. That is what it appears to be from a bare reading. That's why I say each unit will be treated as an independent contract. And will be bound by the terms and conditions specified in the catalog. Then the question, in case the bidder do not lift the minimum quantity, which is what is this? Minimum quantity means unit / unit size minus tolerance limit means ores may have a varied sizes. So in that which are within the specified period, then the amount of SD for incomplete units will stand forfeited. Incomplete SD means incomplete the unit means the remaining amount of the quantity. Then for apropos or in a pro rata basis, it has to be forfeited. So if they have lifted 50, does not lift 50, then security deposit, apropos the non-lifting of the quantity, forfeited. So if the security deposit is say 1 crore, and if they have lifted half, then 50 lakhs you can definitely forfeit.
This man is 10 lakh 81,400.
No, I'm talking, sorry, hypothetical. Yes, lawyer, you understand. A easy numerical figure is always important for easy understanding. So what I say is that suppose if the MD or SD is 1 crore, then if they have lifted half of the quantity, then you can definitely forfeit 50 lakhs of rupees for remaining half. But you have to refund 50 lakhs to him. That is what it says that lifting is plus minus 10%. Minimum quantity. Why I say is that it is within the specified time. What it says is that suppose 4,000 metric tons is there. If they have to lift it within a period of 4 months, correct? Then every month they have to lift 1,000 metric ton after calculation. This is the catalog. You have given a timeline within which they have to.
Government is doing.
Correct. Whatever. Then you have given whatever means So suppose they have lifted, say around 950 metric ton in Omas, instead of 1,000. So 10% plus and minus means they can definitely get the advantage. They will not be penalized for. Suppose if they have lifted 1,010 metric ton. So plus minus 10% means this, because you can't ensure like a true precision is like a Pythagoras theorem or a Euclid's theorem. You can come to a precision when you are lifting. So there may be some kind of a variance. Is it not?
Well, the government has fixed.
So that is what I was talking about. The question is the interpretation. I do not know. Unit is defined.
There is a further clarification. Only see page 67. This will be more clear from this matter. Page 67, Roman 2, clause 8, Roman 2. This is further clarified. The idea which I am trying to tell your lordship is further clear from here.
Yes.
If the successful bidder, para 8, Roman 2.
No, I understand. Fails to lift the material.
Yeah. Fails to lift the material within stipulated time of the contract, the EMD and material value as per clause of abandoned goods for the concerned lot shall stand forfeited with the closing hour of the contractual period until the contractual period is extended under clause contract period of special terms and conditions. If the bidder fails to lift the quantity even during the extended period with the closing hours of the extended period, the EMD and material value as per the clause of abandoned goods for the concerned lot shall be forfeited. Then your lordship may kindly turn to the abandoned clause, abandoned goods clause, page 16. Page 16. Clause 14.
Yes.
Successful bidder must arrange to complete removal of the goods from the site within the date specified in the delivery order issued by OMDC. In case goods not removed in full within the specified date, delivery of goods for the leftover quantity will be treated as cancelled. The goods so left over will be treated as abandoned goods at the risk and cost of the successful bidder. OMDC will have full right on such abandoned goods and will be entitled to dispose of the same in any manner. It will be deemed fit without any reference to successful bidder. Successful bidder will have no claim on the source of blood. So abandoned goods concerning the unlifted quantity will become abandoned goods, and EMD to the extent abandoned goods will be forfeited. And there is a further penalty clause also. The lordship says if he fails to lift 80%, the next penalty against the abandoned goods. If the buyer fails to lift 80% of the allotted quantity, the penalty clause is there. Penalty shall be charged at the rate of 2% plus GST of the sale value of the unlifted quantity calculated from the total quantity allotted. Because this is not the case here. 80% is the different matter. And he is liable for the penalty as per this clause since he has failed to achieve 80%. That's a midway in.
So you have already achieved, you have failed to lift 80%.
Yes.
But you have lifted only 50%.
So abandoned clause has to be read along with this.
So penalty will also be imposed.
Yes.
My lord, I'm reading, my lord. Same 14, my lord. Last 4 lines that my lord and brother left. The successful bidder, same 14, my lord, abandoned goods. The successful bidder shall further be held liable to compensate OMDC for any loss.
When he read a clause B, what is there? Is a penalty at the rate of 2% plus GST. So calculation has to be done.
My lord, these 4 lines also refer, my lord, that B. I am going to that B, my lord. Let me complete these only two lines, my lord.
Sir, I have already read A, B, and 15 also.
15 also.
Not putting the question to you.
I don't think construction. I am already before my lord.
Submit. Reiterate, my lord, 1 to 2 lines, my lord. Only emphasis giving, my lord. The successful bidder shall further be held liable to compensate OMDC for any loss as stipulated in para B below. For all commission and other charges and losses suffered by the OMDC, the sum would be the same would be recovered from the security deposit or any other sum due to the successful bidder, including material value. Thereafter, my lord, penalty provision, my lord. If the buyer fails to lift 80% of the allotted quantity, here, my lord, the buyer has lifted only to the extent of 50%, my lord. So he has failed to
Read, sir. Again, you are accusing him that he has not read. Please read you also. What then what you can do?
if the buyer fails to lift 80%, my lord,
Then
of the allotted quantity, penalties shall be charged at the rate of 2% plus GST. So in instant case, my lord,
Of the unlifted quantity.
of the unlifted quantity.
no, sir.
Of the sale value
Of the same.
of unlimited quantity.
Of unlifted quantity.
Of unlimited
calculated.
From the total quantity allotted.
Correct. In case of an extension of a supply period, sale value to be calculated at the higher price, comparing the price at the time of allotment and the price prevailing at the time of extension, applicable during the extension period, shall be considered for calculation of penalty. No, the above clause is applicable for the unsuccessful lifting as per the terms of the auction document. So now there are two clauses. One clause says that if you have suffered any loss for this non-lifting, then you can definitely recover the amount by way of a compensation against them.
Yes.
You can additionally impose the penalty as well in the event he does not lift 80% of the total quantity. So these are the two components which you can definitely invoke. Question is that how you will suffer. The clause says that the moment they do not lift, it becomes an abundant goods. Abundant goods vest into you the right of ownership reverted. Now you can re-auction. If you re-auction at a higher price than what they quoted, do you think that you have suffered a loss?
That is what they have done. They have sold it.
You have not. So what you can do? You can do only the penalty. Not beyond that.
Also security deposit, from security deposit also it can be adjusted.
You can adjust, but can you eat up the whole? The question is this. You are entitled to deduct from the security deposit. No dispute. They cannot say also. It is permissible under this agreement. But can you eat up the whole or partial? The clauses say that you can do it partially, cannot do it wholly. That's the only zone of dispute.
Yes.
They are not denying your right to recover. The question is how much you can recover. That is the question. According to them, you can not recover beyond 50% of the security deposit.
My lord,
that is what is their question. The stand is.
My lord, my humble submission is last submission only. I will not tell again. My humble submission is, my lord, what I am understanding here, it is not written that in ratio to the incomplete amount, SD will be forfeited.
What are you talking? Very clear from the language. If you go by a definition of an abundant goods, if you go by your right to claim a ownership on the abundant goods and resale it, that shows that you can only deduct on the basis of the abundant goods, not on the basis of the other goods, which he has already lifted. It's only the leftover. Your authority have not given you correct instructions. You ought to have put this question that you are talking about clause 6.3. What about these clauses, clause 14?
My lord, I have discussed, my lord. But
and then what about clause 8? Why you are not saying what is their step?
My lord, I have discussed with them, but they hold this view, my lord. So my lord will decide. My Lord will decide that this is not a precedent for
This will be a precedent.
Once your lordship decide 141 comes.
It is a precedent. Cannot go in this way. When it is not precedent, suppose if you concede something.
Yes.
We say that yes, this is a special case where you have done, it will not be treated as a precedent. But here we are deciding the clause, we are interpreting those clauses, the different clauses of the contract. Will it not be a precedent than what we are doing?
They are saying that all will ask in this manner more.
Everyone will ask.
There are
different clauses we have to decide. We have to decide. Yes.
Item 36. Yes.
36. Which line?
36.
36 have appeared for OP number 1 and 2. I asked my lords for filing counter. I have received the authorized cover. I'm asking further time to file the counter.
The first extension or second extension?
It is the second extension, but in fact will be third, I think, because in one time matter was listed, but the matter did not reach on that.
That was by the court. But it does not mean. Once you are freed, then you will have to pay some.
Well, received
That is my principle. First extension I gave automatically. Second extension.
I will also see this.
You are appearing
For the petitioners.
because the subsidy submits that.
$10,000.
37.
37, you will serving a copy of the counter affidavit.
But I'm there for the petitioner, my lord. Listening. I'll file my rejoinder, my lord, within 2 weeks.
Within
Within 2 weeks.
at the time of the hearing of the instance,